Special Counsel asks judge to limit Trump's public statements in federal election subversion case. Justice Department prosecutors want U.S. District Judge Tanya Chutkan to reel in Donald Trump's public statements in the federal 2020 election interference case against him, asking her to place a court order limiting what he can say, according to a newly released filing. The request for a limited gag order, filed in recent days, represents the most direct response from prosecutors with Special Counsel Jack Smith's office to the former president's public statements to date. The Justice Department said the order is needed to protect the integrity of his trial in March. Trump has already been ordered not to intimidate potential witnesses or talk to them about the facts of the case. In making their argument, prosecutors pointed to false public statements Trump previously made around the 2020 vote to erode public faith in the administration of the election and intimidate individuals who refuted his lies. The defendant is now attempting to do the same thing in this criminal case, to undermine confidence in the criminal justice system and prejudice the jury pool through disparaging and inflammatory attacks on the citizens of this district, the court, prosecutors, and prospective witnesses, prosecutors wrote in their filing. Chutkan, an Obama appointee overseeing the criminal case in Washington, D.C., hasn't yet made a decision on the request. Trump blasted the special counsel's motion in a Truth Social post Friday, calling Smith deranged and claiming that it was a move to silence the leading Republican candidate who could challenge President Joe Biden in the 2024 election. The former president doubled down on his attacks at an event in Washington, D.C., on Friday evening, accusing the special counsel of infringing on his rights. "Did you see today that deranged Jack Smith wants to take away my rights under the First Amendment, wants to take away my right of speaking freely and openly?" Trump said. The prosecutors specifically asked for a court order limiting Trump's ability to speak about the identity, testimony, or credibility of prospective witnesses, and statements about any party, witness, attorney, court personnel, or potential jurors that are disparaging and inflammatory, or intimidating. In the filing, federal prosecutors cited Trump's recent criticism of former Vice President Mike Pence and Bill Barr, the former Attorney General under Trump, both of whom could be called as witnesses in the trial next year. Prosecutors also noted Trump's previous social media posts against Chutkan, Trump-hating judge. Trump, they noted, has called the special counsel prosecutors a team of thugs, and has attacked Smith as deranged. The prosecutors said they do not want to block Trump from being able to quote or reference the court record or to proclaim his innocence. They are also seeking a court order that would block Trump's lawyers from polling potential jurors for the case without the court's approval first. Defense attorneys can poll residents who could make up the jury pool in their case with general questions around the issues of the case. Those findings can be used to argue for a change of venue. Consistent with its obligations to guard the integrity of these proceedings and prevent prejudice to the jury pool, while respecting the defendant's First Amendment rights, the court should enter the proposed orders imposing certain narrow restrictions on the parties' public statements regarding this case and governing any jury studies the parties may undertake, the prosecutors wrote to the judge. The federal election interference investigation is one of 4 criminal cases against the former president. Trump is facing 4 charges in this case, including obstruction of an official proceeding and conspiracy to defraud the United States.